My name is Matthew Ford, Senior Assistant Attorney General. It is an absolute pleasure to be speaking in front of everybody here today. I'm sure you've heard it a million times, but welcome to the Cyber Summit. We are incredibly grateful and excited that you have all decided to spend today and tomorrow with us while we discuss what is really an incredibly important issue today. Tim has brought in a lot of great and talented people to discuss cybersecurity because it is such a relevant thing here today. Regardless of whether or not you have a small business or you work for a large company, perhaps you're a government employee, maybe you work for a nonprofit, at some point you're going to have to deal with cybersecurity issues. And so collaboration is incredibly important so we can all get through some of these major issues. Now, cybersecurity is something that I do on a daily basis. It is also something that I am incredibly passionate about, just as our Attorney General is as well. I am the quintessential data nerd, and so I am incredibly excited to be speaking about something that I truthfully love. Now, some of these statistics have been already mentioned here earlier today, but I feel like every good presentation needs to start with some statistics in order to set the stage and put things in perspective. According to Forbes, there were 2,365 cyber attacks in 2023. Now, the total victims for that is over 340 million people. 2023, as opposed to compared to 2021, saw a 72% increase in data breaches. Around the world, the average data breach cost approximately $4.88 million. Now, you can find all sorts of statistics concerning this issue, but the bottom line here is data breaches and cyber incidents are going to continue to rise, and the costs associated with those data breaches will continue to rise as well. There's nothing to say that it won't. So ultimately, what is the point of this presentation? Why is it that I'm standing in front of each and every one of you today speaking about this issue? It's not because I like to hear myself talk, although that part is true, as my coworkers in the front row will testify to. I am here today because the Office of the Arkansas Attorney General is in a very unique position. On one hand, as I will discuss throughout this presentation, we are in an enforcement mechanism as it relates to data protection and cybersecurity. On the other hand, our office is also a resource because at the end of the day, myself and everyone else in our office is a resource to the public. At the end of this presentation, I'm sad to say that you won't have all of the answers. You won't have all the clear answers as to what cybersecurity measures that you or your organization may need. But my hope throughout this presentation is that you take away some of the basics to the laws that our office enforces and some of the legal basics of our enforcement efforts, and potentially and possibly some high-level considerations that you can take back with you to possibly avoid regulatory or enforcement actions as it relates to both data governance and cybersecurity. At the end of the day, that we are collaborators and we are here to help educate the public. And so I will mention this again later on in the presentation, but if our office can ever be a resource concerning these issues, feel free to reach out. That is why we are here. So I work for what is called the Public Protection Division. Arkansas, just like a lot of other attorney general's offices, have a team that are dedicated to protecting consumers. The Public Protection Division is responsible for protecting consumers from scams. We're also responsible for mediating disputes with businesses, educating the public, or as we're discussing here today, we're here to enforce and help protect the public from the consequences of data breaches. And we're also here to help protect against violations of consumer privacy. Now, I could stand here and go over in my own words exactly what it is that we are responsible for doing, But luckily for us, the legislator has done that for us. This particular statute dictates all of the things that our offices are responsible for doing. We are a central coordinating agency and clearinghouse for receiving complaints of illegal, fraudulent, or deceptive practices. Now, every day, our office receives numerous complaints about businesses that, quite frankly, have been alleged to have done bad things. And our office has numerous dedicated investigators that spend every day at work helping consumers who, quite frankly, have just had a bad day. Possibly someone has scammed them, they've lost money. And so they're incredibly dedicated. We are also responsible for assisting and cooperating with other state authorities as well as federal authorities. Now, ultimately, to protect the consumer public. Now, this is an important point. Our office regularly coordinates with federal and other state attorney generals on matters, assuming, of course, that the interests of Arkansans are protected. Now, some of these federal authorities, such as the DOJ and perhaps other state attorney generals, this is an important issue because, as we will discuss a little bit later, if your organization collects data from numerous residents from numerous different states, you have a whole lot of entities that you have to deal with in case of a breach. Arkansas is certainly one of them, but there are other state attorney generals as well. And so it's important to remember this because the liability can be incredibly extensive, right? You suffer a data breach with residents of 50 states, that's 50 separate attorney generals that you may have to respond to if the circumstances dictate it. We are also responsible to conduct investigations. As I mentioned a second ago, we have investigators who are responsible for doing that. We have the authority, as I will continuously discuss here today, to take appropriate action that, of course, affects the interest of our consumer public. I will discuss it again, but the Arkansas Attorney General and most Attorney General's offices in the country have broad investigatory powers. There are lots of things that we can do if the facts warrant it. But it's not all about enforcement. Again, I don't want everyone here today to think that we're just some big bag wolf that's all about enforcement. We're also here to promote consumer education, which is why I'm here today. We are responsible for educating the public to hopefully to where they are not victims of scams themselves. But we also are here to undertake activities to encourage business and industry to maintain high standards of honesty, fair business practices, and public responsibility. So again, like today, we're not just an enforcer, but we are also an educator. Our office is a resource. Because remember, why we're all here today is that one of the best ways to prevent harm, right, is not to solve the problem on the back end. It's to hopefully prevent it from ever happening in the first place. Now, finally, obviously, we're here to also investigate violations of laws. I will go through a couple of these laws throughout this presentation, but the two primary ones that we will discuss today is the Arkansas Deceptive Trade Practices Act and the Arkansas Personal Information Protection Act. I opened this slide, the data landscape is what I call it, right? There's three relevant topics here that I'm going to talk about, but that's data privacy, data governance, and cybersecurity. The reality is that we live in a data-driven world. Companies have discovered, and this is not necessarily a bad thing, but companies have discovered that one of their most valuable assets is the data that they collect from consumers regarding their habits. Whether that's what it is they see, what it is they hear, watch, what they read, what they purchase, the effect here is to create a blueprint of someone's interest. And so a lot of companies have lots of data about not just Arkansas consumers, but consumers in other states in the United States, but as well also the world. Now, this data can be used in things like targeted advertising or data sales. The problem, of course, just as companies have discovered that this data is valuable, so have cyber criminals, right? If the data is valuable, they want it. And so this creates an incentive for cyber criminals to engage in these cyber attacks. So this brings up two related concepts that are distinct. And so I want to talk about those two concepts. And one, of course, is data privacy, as a term that many people here have probably heard. And then, of course, there's data security. Data privacy focuses on the collection and use of personal data, whereas data security is more of what we think of when we think of cybersecurity, and it's protecting that information once that information has been collected. Both data privacy and data security are important for an organization, and both of these concepts are further related to the concept of data governance, which I will mention here shortly. A quick pause here, right? This presentation largely focuses on the Attorney General's authority and responsibility in response to data breaches. The truth, though, is a little more complicated. Data collection practices and cybersecurity often go hand in hand to protect consumers. Think about it this way. Data security is only needed, of course, if you actually collect the data in the first place. So minimizing the data that your organization or that you personally collect is a great way to minimize risk, just like having adequate cybersecurity practices. And that's fundamentally what we are speaking about here today. When we talk about cybersecurity, what we're really talking about here is lowering that risk. There are lots of risks, especially as it relates to cybersecurity, right? A data breach causes numerous harms to a business. There's financial harms, there's reputational harms, there's regulatory harms, but there's also harms to the consumer whenever there's a data breach. And so adequate cybersecurity measures help mitigate that risk to not just the businesses themselves or the organizations, but also to all of those people whose data it belongs to. Now, the same, though, is true not just for cybersecurity, but also for data governance. So let's talk about data governance. What is it? Well, data governance is a system of internal policies related to how organizations manage, access, and secure data. Now, related to this point is the concept of a data lifecycle, right? Which is just a fancy way of basically saying we have to manage, or an organization needs to manage that data throughout its lifecycle. So whether that is the collection of data from the time it was collected, or the storage of that data when it's not in use, or when the data is being processed, or when the data is being used, or maybe perhaps an organization no longer needs the data, so how do you go about destroying it? At every step of this way, you have to, as an organization, manage that life cycle, not just protect it at the time that it is in storage, which is what we kind of think about when we think of cybersecurity. The fact is that data security is an important component of this, but it's not the only one. And the reality is when the Attorney General, not just the Arkansas Attorney General, but any government agency, when they look at an organization's practices, they're going to look more than just an analysis of what cybersecurity stacks that you have, what hardware that you have, what software do you have, right? We're going to look at your policies and your practices as to why the data was collected in the first place when we're looking at what your data governance practices are. So now that I've provided a little bit of background, let's talk a little bit about the law that the Arkansas Attorney General enforces, or the laws. The Arkansas Deceptive Trade Practices Act is a statute that the Arkansas Attorney General primarily enforces, right? We are the primary enforcer of this statute. And this is one of our central ways to hold businesses accountable for deceptive or bad practices. Now, the ADTPA, which is what I'm going to call it here on out, contains a non-exhaustive list of deceptive trade practices, right? So there is a list of what things that we're allowed to go after, but it's not exhaustive. There's also a catch-all provision that essentially prohibits unconscionable, false, or deceptive acts or practices in business, commerce, or trade, right? It's not just deceptive practices, it's also unconscionable ones, and we have broad authority to investigate all sorts of conduct. And so the two important points here, again, not just deception, but also unconscionability, but also it's not exhaustive, right? There's lots of different things that we can investigate. So what is an unconscionable practice? Well, the case law says an unconscionable practice is a practice that affronts a sense of justice, decency, and reasonableness, right? And so, in other words, regardless of whether or not your organization tells the truth about something, there are potentially some things that we're not prepared to say are okay, right? And so that's what we're talking about when we talk about an unconscionable practice. Does it affront the sense of justice, decency, and reasonableness? Now, the Attorney General, as I said before, is the primary enforcer of this statute. The Public Protection Division, the division in which I work, is uniquely situated as a government enforcer because we have that statutory authority to hold businesses and people accountable for questionable practices that harm consumers. The ADTPA's language is extremely broad, and the courts have interpreted this to be the case. The Arkansas Supreme Court has said that the General Assembly cannot be expected to envision every conceivable violation under the DTPA. In short, that essentially means that it's not fair to expect someone to codify every type of action that might violate the statute. That would be impossible. And so again, the Attorney General has that flexibility depending on the circumstances and depending on the act. So what's the problem? If someone violates the ADTPA, what are the consequences or the potential consequences? The ADTPA provides civil penalties of $10,000 per violation. Now, $10,000 doesn't seem like a lot of money, but you have to remember that that is per violation. In the context of a data breach, the damages can add up extremely quickly. Let's take, for example, a data breach that affects the personal information of 50,000 Arkansans. That's actually not that large, right? There are data breaches that far exceed that. If you calculate the $10,000 civil penalty times 50,000, you can see how the damages can quickly add up. Now, to be clear, I'm not suggesting that every violation is going to encounter fines of millions upon millions of dollars. That's not a fair assumption. Nevertheless, as an organization or as an individual, you have to fully understand that the risk involved when there is a data breach and the potential liability that can happen. Because again, that's just Arkansas. That's not talking about all the other states if those particular DTPA statutes are violated as well. At the end of the day, your organization, when it contemplates its risk management, has to consider the potential liability. But it's not just the civil penalties. The ADTPA allows for attorney's fees, costs and expenses, and perhaps one of the biggest things, it allows for injunctions, right? If an organization fails to implement reasonable security practices, which I will talk about here shortly, under the ADTPA, we can ask a court to force you to do that, force the organization to do that. So whether that's institute practices or policies related to cybersecurity, or perhaps it's requiring MFA or some of these other things, the ADTPA gives us that broad authority to force that upon organizations that we find have violated the ADTPA. There's also consumer restitution, right? If consumers are harmed financially, we can seek restitution for them. And finally, perhaps the most serious consequence of all, the ADTPA expressly allows us to seek to have businesses not able to conduct business in Arkansas if we find that their practices warrant that. Now, obviously, that is incredibly severe, and it would have to be incredibly bad for that to ever get enforced. But the fact is that it is a possibility because we have to be able to hold businesses accountable for incredibly bad practices. The next statute that we enforce, and we are the primary enforcer, is the Arkansas Personal Information Protection Act. And that is a statute that perhaps many of you are aware of. Every state in the United States, and by every, I mean every state, has a data breach notification law. This is ours, right? And the legislator has found the purpose behind this statute is to ensure that sensitive personal information about residents is protected. That is the goal behind the statute. To that end, the purpose of this chapter is to encourage individuals, businesses, and state agencies that acquire, own, or license personal information about the citizens of the state of Arkansas to provide reasonable security for that information. Now, of course, as I mentioned earlier, a lot of this encouragement comes through education. We're not just the big bad wolf. But nevertheless, there is encouragement through enforcement, and the statute expressly allows us to do that. Not allows us, requires the Attorney General to do that, to ensure organizations have reasonable security practices to protect the data that they are collecting about Arkansans. Now, obviously, ideally, organizations will voluntarily comply with the law themselves. That is the goal, and we hope that most organizations, and I believe most organizations do that. They comply voluntarily because we're all on the same page to protecting Arkansans. Nevertheless, we have the hammer should it be needed. One thing to note about this is the word reasonable. And we're going to see this word come up again in the actual statutory text itself. You only need to provide reasonable security for the information. This is not a perfection standard. No one expects perfection. In the world of cybersecurity, perfection is actually not really possible. There are zero-day attacks, right? There are things that perhaps no one could predict. And so all we're requiring is reasonable security, and that will depend on a lot of different factors. Before we get into the actual statutory text, let's look at couple of the main definitions, right? These are fundamental definitions under the Personal Information Protection Act that we need to be aware of. One, breach of the security of the system, right? What constitutes a breach? Well, the technical definition is it is an unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of personal information maintained by a person, right? And so there's a few components here, right? It's not just that there was a disclosure. A disclosure obviously is an important part as it relates to data breaches and data security, but it's also it's the integrity and security, right? Integrity meaning that the data cannot be modified. And so we have to look at all three of those. And as later on in the presentation, I will talk about the CIA triad, but that's generally what we're looking at. Now, what is personal information? That seems like a common sense thing, right? But it's not. It is defined by the statute. It's the first and last name in combination with one of several different data points, right? So some of those data points include things like social security numbers, also like credit card numbers, account numbers, driver's license numbers, biometrics, things like your fingerprint scan or your retinal scan or DNA, and medical information, right? Anything that's protected health information is included. So that is what we're talking about that when we talk about personal information that is covered by our data breach law. So what does the people require? Personal Information Protection Act. Well, first, you need to take reasonable steps to destroy customers' records that contain personal information. As we talked about earlier, at some point during the data life cycle, there's going to be a time when you no longer need the information. And so as an organization, you have to decide, one, should I destroy this information? And then two, how do I go about doing that? And so the law requires that when you make that decision as an organization, you need to take reasonable steps to do that, right? You can't just leave this stuff out in the open for everyone to see because you no longer need it. You have to be a good data steward in that regard. The provision that really we hit on a lot, though, has to do with maintaining reasonable security procedures and practices appropriate to the nature of the information. And again, that's to protect it from access, destruction, use, modification, or disclosure. It's not just disclosure. Harms can be had on consumers regardless of whether or not that information was disclosed to someone else. If the information is modified in any way, right, that can have consumer harms as well, or cause consumer harms. And so again, we see this word, reasonable security procedures. What is reasonable? And again, that depends on the circumstances. Now, the Personal Information Protection Act is actually enforced through the mechanism present in the Deceptive Trade Practices Act, right? So those penalties that I discussed a minute ago apply here under the Personal Information Protection Act. And the one that we're all familiar with is what happens when there is a data breach. And if you've been in this business for long enough and you've done this, some people say that it's not a matter of if, it is a matter of when you suffer a cyber attack. So what is it that you do when there is a data breach? And the Attorney General has authority in this space. First, if you have a breach, an organization is required to disclose that breach to any affected people, and that has to be done in the most expedient time and manner possible without unreasonable delay. Now, a couple points in this statute is the data has to reasonably believe to have been acquired by an unauthorized person. If someone's in your computer system or your network and it doesn't look like they actually accessed any of the personal information, then you may not have to actually disclose that, at least to the individuals. But also, if it has to be unencrypted, right? We'll talk about some of the cybersecurity common issues, and if the data is encrypted and there's no possible way for someone to read that information, then it doesn't need to be reported, right? That is the value of encryption. But if there is a breach and you know that people's information was affected, you have to let them know very quickly. Now, there's one little caveat there, and it's a caveat that I would urge most people not necessarily follow through with. Notice is not required if there's no reasonable likelihood of harm to consumers. And so if you know for a fact that there is no harm, then under the statute, you don't have to provide the notice. And so that previous slide dealt with notifying the individuals whose data was stolen. But this is the requirement as it relates to the Attorney General. If more than 1,000 individuals are affected by the breach, at the same time you provide notice to the consumers, or within 45 days, whichever is sooner, you have to also notify the Attorney General's office. And those notifications come through our office, through public protection, and they come through me. And that gives us an opportunity to look and to see if there's any information that we need to ask or follow up on. Because again, at the end of the day, public protection is about protecting the consumers. And so we want to make sure that notice has gone out to the consumer, that they know how to protect themselves and their information so they don't suffer some of the bad consequences of a breach. There's record-keeping requirements in the Personal Information Protection Act. An organization has to retain a copy of what the statute says or calls it a written determination of the breach and any supporting documentation within 5 years from the time the organization determined that there was a breach, right? And this information can be requested by our office. In fact, if we request the information, that has to be provided to us within 30 days, assuming, of course, we don't provide any type of extension. And so when you have a breach, these are the records, especially if it's going to affect more than 1,000 people or 1,000 Arkansans, you need to make sure you retain these records because it is possible that we could request it. And it doesn't necessarily mean we request this information that just means that we're looking to enforce. Sometimes it just means we want to understand what's going on. We want to make sure that the consumer is protected, right? What data was taken. If this was something that we could see happen to someone else, we need to know about that, right? Because again, we are all about education, and we just want to make sure that the consumers are protected. As I mentioned before, the Attorney General has a lot of power as it comes to investigations. We have incredibly broad subpoena power, right? In all litigation that our office is involved in, we are capable of subpoenaing any person and his books, records, or other documents. And we also have the authority to administer oaths for sworn testimony. The ADTPA also has its own investigatory allowance there, which is called civil investigative demands. And what these basically are basically demands for information. We can ask for information, we can ask for documents, we can ask people to sit for what is similar to a deposition before we even do litigation. This is the initial stages of an investigation, like you would think of like a law enforcement officer. These are things that we can require. These CIDs are enforceable in court should an organization not comply with them, and we can seek penalties and sanctions for non-compliance. So why does the Attorney General's office care about this, right? That's a fundamental question. Why do I care about this? Why does public protection care about this issue? It's because data is a consumer issue, right? When we think of consumer protection, we think of scams. We think of taking advantage of people that don't have the capabilities of understanding things, right? That's what we think of. But the truth is data is a consumer issue. And so this is a little flow chart that kind of illustrates the point here. When an organization collects a lot of valuable data about Arkansas consumers, at the end of the day, consumers have little actual control over how companies use, collect, or retain that data, right? Once the data is given, depending on certain state laws, it can be hard to actually modify how a company uses it. And so this can provide an incentive for companies to collect as much data as possible, right? Because it is profitable. And again, I'm not speaking to whether or not that's bad or good, but it's just a fact. The data is valuable. But all companies, regardless of whatever cybersecurity measures they have, are or can be vulnerable to cyber attacks, right? That's the whole notion of zero-day attacks is that we didn't know this was even a vulnerability. We didn't know that this was an issue. So how do you protect against something that you know nothing about? And so the consequences of that increase to consumers as more and more data is collected, because there is always a non-zero risk of that data being published out on the dark web or somewhere else. And so when a company suffers a data breach, consumers ultimately are the ones that have to spend time and money to remedy or limit the harm. At the end of the day, we have concerns over identity theft and fraud risk. According to the Bureau of Justice Statistics, in 2021, about 9% of U.S. residents aged 16 or older had experienced identity theft in the last 12 months. 9%. About 1 in 5 had experienced identity theft in their lifetime. About 59% of identity theft victims had financial losses for a total of $16.4 billion, right? And that's in 2021, so you can imagine what those numbers are today. I would place bets that the number is substantially higher. And so when we talk about data as a consumer issue, there are real-world consequences to these data breaches. And so when I talk about data governance considerations, what I'm really talking about is, do you have policies or practices about how to manage and how you collect the data, right? And these are not necessarily requirements. These are just things to consider as an organization as to limit your risk, right? Data minimization. Are you limiting the data that you're collecting to what is necessary? If you don't need dates of birth, why are you collecting them in the first place, right? Purpose specification. What are you using the data for? If you're collecting it for one purpose, should you limit yourself from using it for another? That might be one way to minimize risk. Secondary use, that's related to the last point on purpose specification. Use the data for why you collected it. If you are collecting sensitive information, like for example, protected health information, right? Perhaps you need to take extra precautions. And in fact, as we'll talk, HIPAA does require that. But also transparency. Tell people, what data is it that you are collecting and why are you collecting it, right? Give people that informed choice. And finally, security measures secure the collected data from unauthorized disclosure, use, modification, or destruction. And really what we're talking about there is what some of the technologists in the room or know as the CIA triad, really the confidentiality, integrity, and availability. We're worried about not just protecting the data from disclosure, but we're also worried about protecting the data from being modified in a negative way or even a positive way, but also making sure that the data is available to those who need it, right? You don't want a situation where your organization is subject to a data breach or a cyber attack. Perhaps no data was ever released to the public or to anyone else, but yet your systems are still down and you have no way to recover your systems, right? That's not beneficial to the consumer at all. And so those are the three things you have to consider. And related to those three, you have the issues of data at rest, data in transit, and data in use. So there's three stages of data use that you need to consider when you're talking about the CIA triad. Now, all of this ultimately is related to this concept of data classification, right? As an organization, you're concerned with what data that you have and what type of data it is. Every portion of data has different standards, right? Some data should be more protected than others, right? If you're dealing with protected health information under HIPAA, well, there's whole regulations that talk about that. The privacy rule, the security rule, right? That data might be protected a little bit different than, for example, a unique user ID that's not used in any other website, that's not personally identifiable information. And so as an organization, you have to be able to classify the data that you have into different sections so you know what protections you need to put in place. Now, the question that we're all here, and perhaps some people want me to give a great answer on this, and unfortunately, I can't. What cybersecurity measures do I need? What cybersecurity measures does my organization need? But the reality is this is a case-by-case inquiry, right? There's a lot of factors that go into this. What type of data is involved? What is the data that you're collecting and what is the data that you're storing? Again, this relates to data classification, right? Certain data, of course, needs higher protections. There's other legal and regulatory requirements, right? Under HIPAA, protected health information has certain guidelines. Banks are subject to a different federal law related to the privacy of consumers, right? What about the size of the company, right? Obviously, a mom and pop shop can't afford the same cybersecurity protections that a large company might, right? And so these are all considerations. Now, related to this, cybersecurity measures, we're talking administrative, physical, and technical controls, right? This is lingo for all the cybersecurity people in here, but that's what we're talking about. We're talking about all three of those. Regardless of how much of something you need, these are the three categories of protections, of measures that any organization needs to consider. So when we talk about administrative safeguards, we're talking about policies and procedures such as employee management, employee training, making sure people understand everything there is to understand about your organization's data access, use, and management. Physical safeguards, right? Think security guards, think cameras, wiping devices when they're no longer needed, ensuring that they are completely destroyed. Locking your workstation, don't leaving it up, especially when you have people in the public around. These are all the physical safeguards that everyone should consider. And then finally, technical safeguards, things like access control, encryption, logging and monitoring, firewalls, all these basic technical controls that everyone should also consider. And so when we talk, what are some common cybersecurity issues, right? Well, there's a lot of them. And as we do a lot of these investigations and you hear them in the news, there's a lot of different categories that come into play when we talk about what we see on data breaches, right? Identity and access management failure is a large one. especially as it relates to privileged accounts. What do I mean by privileged account? Well, essentially what I mean is someone that has a high level of access, right? Your administrators. When those credentials get stolen, it's a real big problem. That opens up the door to all sorts of systems. And so when we see this account or this identity and access management failure, a lot of times that's what we're seeing is we're seeing credentials for privileged accounts that have been taken. Multi-factor authentication also can be a large thing. I believe one of the speakers, I believe Jen Easterly, had talked about multi-factor authentication, right? It's having the second thing there in case your credentials are taken. This is a very simple way to oftentimes minimize account access. Insufficient network segmentation, right? Separate your systems out. Does all the systems need to be on the same network? Perhaps not. If you have one network or one system that has a lot of sensitive data and other systems that don't, perhaps you should separate those out a little bit. So if one gets taken over, perhaps the one with the sensitive information does not. Patch management, right? All those updates that you get on your computer systems, you have to make sure that you have great patch management, that those are constantly being updated. Insufficient training, right? It's something our office does. It's something every organization should consider. That is, train your employees on best practices, right? What is it that they are supposed to do? Insufficient logging and monitoring, right? Are you going to detect a cyber attack if you have no way to log or monitor it? You need to make sure that you have that in play. Firewalls that aren't set up properly, right? Are all of the ports that should not be open, are they in fact closed? Verify that, right? Don't just assume that they are closed. And all of this ultimately relates to this concept of perhaps zero trust security model, right? You know, there's this notion that once I'm in the system, I'm trusted because I'm in the system. But that, of course, creates an issue where someone gets access improperly and all of a sudden now they can go laterally move all over your computer systems. So sometimes the best policy is trusting no one, right? Which is a horrible negative way to look on an outlook at life, but potentially a great way to look at when you talk about cybersecurity. And then phishing is a huge issue, right? And we see this in every office in America. You're gonna get emails that seem legit, but they're clearly not, or perhaps not even clearly not. A lot of these emails are pretty sophisticated now. And so it's watching those emails and training your employees about that. And so this is a case study, right? This is a case that Arkansas, along with many other states, worked on. And to be clear, I'm not picking on this particular company in any way. This is just a great example of what can happen during a breach. So Blackbaud Incorporated is a company that provides software to organizations that connect donors and manage data about their donors, right? On May 14, 2020, Blackbaud discovered a ransomware attack that resulted in a lot of data being taken, a lot of sensitive data about donors. It affected over 1 million files related to over 13,000 or a quarter of Blackbaud's customers. Now, this is an example of a multi-state investigation and multi-state cooperation among attorney generals. There was a settlement, right? The settlement required a financial payment of almost $50 million to all the participating states that took part in that case. It required injunctive relief, right? It required Blackbaud to institute measures so something like this may not happen again, or if it does happen again, maybe the consequences will be less severe. It required security incident reporting to the CEO and board, enhanced employee training, appropriate resources and support for cybersecurity, total database encryption, dark web monitoring. It required specific security requirements in regards to network segmentation, patch management, intrusion detection, firewalls, access controls, logging and monitoring, and pen testing. To test Blackbaud's compliance with the settlement, they have to require third-party assessments for a total period of 7 years. This was a relatively large settlement, and this is an example of what can happen to organizations that are the target of an investigation. Ultimately, the moral of this story, right, is if a company or organization fails to implement reasonable security practices, the Attorney General can act to make sure that these security practices are implemented to protect consumers going forward, right? It is far better for both the consumers and organizations themselves to implement these security practices on the front end. And the Attorney General, along with numerous other resources, are available to help you, guide you through this process so we don't have to come in, or regulators don't have to come in on the back end dealing with this issue. The reality is data is valuable, right? I've said that a million times. I fully recognize that. And so as a good company, as a good organization, as a good individual, you should protect these assets because they are valuable. But it's to protect the consumers as well. Because of those things like identity theft and some of these other consequences, every day people are affected by identity theft. And for some are more severe than others. But there are literally people that their lives are almost ruined because someone got their information in one of these data breaches. Every day you can go on the dark web and you can buy people's personal information. You can buy their social security numbers, right? I was a prosecutor for one time. I remember I had an identity theft case. Someone from another state completely took over an Arkansan's identity, right? Caused all sorts of harm. It took that couple years upon years to fix the issues, right? And so it's not just about the organization, but we're here also because ultimately we want to protect the Arkansans whose data that belongs to. Enforcement is a necessary component to protect consumers. And so utilize all of these resources that are available to you here today, the people that you meet, all the different federal agencies that have been here today. Utilize all these resources to protect yourself and to protect everyone else. Because at the end of the day, cyber attacks are going to continue to increase, and the consequences will only become more and more severe as we are this data-driven society. These cybersecurity issues are a priority for our office, for the Attorney General. And if we can be a resource throughout any of this, please reach out. At the end of the day, we are all here to collaborate in order to protect the Arkansas consumer. Thank you.